Well, good morning, ladies and gentlemen. I do not speak your beautiful language, so you will have to listen to me in English. I hope I will speak slowly enough so that our well-trained translators will be able to follow. First of all, let me express my appreciation to you, Director Laganovskis, and to the organizers of this conference for having invited me to come here. I see a room full of judges, and that's always a little bit frightening for a lawyer. That's what my current profession is. But as the director told you, I have a history of, while being a lawyer, I was actually more a public official working for the German Justice Ministry for many years. And then, as you just heard, for what is now called the European Union Intellectual Property Office as a vice president until 2005. It's all a long history. I have a particular pleasure of being in this country because my family, that is to say my parents, were actually both born in Estonia, not in your country, but in the neighboring country to the north. My father in what was then called Reval and is now called Tallinn, and my mother in what is now called Rakvere, which is a town to the east in Estonia, and was then called Wesenberg. They belonged to the German minority in that country in the period before the First War and left already before the revolution took place, and many other Germans stayed or left with a sad history that our people have brought to you over the decades. We are part of that history. So it's nice to be back here, particularly nice to have sunshine and nice weather, which when I left Berlin, as you know, we had elections on Sunday. It was rainy and a rather dark day under several aspects, but I'm not going to talk about Germany or German history or German legislation or Germany or European Union. But my task has been, I've been invited I've been invited to talk to you about new legislation and new case law. That's what I'm going to do. No, it's okay. I will not fall down. It's okay. Thank you very much. Why new legislation and why new case law? It's quite simple. On 1st of October, which is in a few days, the final step in the legislative so-called trademark package will come into force. The trademark package is the legislation adopted in Brussels in the reform of the existing system or in the evolution of the existing trademark system, which consists of the European Union trademark regulation, used to be community trademark regulation, and in the directive, which is addressed to member states who have to adapt their domestic legislation to the mandates of the directive. This is something which has begun in 2013, actually even earlier, and the corresponding legislation was adopted at the end of 2015, entered into force partially in March last year, and for the remainder this year in a few days. So that's the first thing, legislation. I have reproduced on this slide the exact name of the legislation as it is currently in force. We talk about, first of all, the Directive 2015 of the European Parliament and of the Council of 16 December 2015. That is the new directive which will oblige member states, including, of course, all of this country and the neighboring countries, to adapt their legislation to this new so-called recast directive. It's a much longer piece of legislation, and I will highlight some of the elements which are new as compared to the original directive, which already dates from 1988. The 1988 directive basically was never amended. A small change had to do with the coming into force of the agreement on the of the European economic, the enlargement, the agreements with Norway, Iceland, and Liechtenstein, the EEA agreement. That is the directive which will govern your procedures in this country to a great extent in the future. And we have now recast, also only since about 3 months, the regulation of the European Parliament and of the Council on the European Union trademark. I'm sorry, there are a few typos in this slide. It should, of course, be on the European trademark rather than off, but that has to do that I was spending part of the night before last to produce these slides, so some of them are not quite up to date. Anyway, that is the European Union trademark regulation that is now being called the abbreviation EU TMR, which has replaced the original community trademark regulation. You have to relearn the numbers of the paragraphs because this is a much longer piece of legislation now. It is supplemented by 2 implementing delegated regulations. These are Commission legislation of a secondary or tertiary nature. They have a date of 18 May, but actually they were also only published a few days ago in the official journal, and they are the implementing regulations which supplant the previous implementing regulation. All of this has to do with proceedings at the EU IPO in Alicante rather than your national legislation, but it is useful when you consider implementing the directive in your country to look at how some of these procedural issues are implemented. There are some changes in the formalities. We no longer talk about the European Community, but the Union. The office has changed its name, as you have seen. The regulation has a new name. The mark itself is now called EU trademark. The courts that are in part sitting here in what used to be the Community Trademark Court and Community Design Court is now called the European Union Trademark Court. The president of the office has become the executive director. I don't know whether you are also going to change the title of your office to, I don't know, someone thought the name president was no longer suited to the office in Alicante, so they invented executive director. A few words on substantive trademark law, what is different from, in comparison to the previous legislation. We talk first about registrable signs. The previous legislation required that a sign, in order to be registrable as a trademark, must be capable of a graphic representation. That graphic representation has been replaced by a definition which takes up some of the previous case law, and the only requirement now is that a sign must be represented in a manner which enables the competent authorities and the public to determine the clear and precise subject matter of the protection afforded to its proprietor. So no longer graphic representation. You can imagine you have moving trademarks, you have sound marks, and you have some other holograms and others where the previous graphic representation requirement presented some problems. This provision is applicable in Alicante from the 1st of October this year. It wasn't applicable previously. It will become applicable in your countries from the date that you implement the directive. The directive, as I pointed out to you, was already adopted in December 2015, and the member countries have 3 years to adapt their legislation to the new format of what the directive also requires. So also in your countries, you will have trademarks which are no longer truly graphically represented, but which have some other manner of representation. All of this, of course, requires that you can deal with these trademarks by electronic means, register them with an electronic representation, let's say a visually visible file or a sound file, and I'm sure that your office in this country and the neighboring countries will be preparing to adapt their legislation to this requirement. This is Article 3 of the directive, which is worded exactly in the same manner as is the regulation. There is a further addition on the absolute grounds of exclusion from registration. Among those, as you will recall, there are some which are absolute exclusions. These are signs which represent the goods themselves, signs which are technically functional and aesthetically functional. There are different ways of expressing this. This is Article 4.1e of the directive. There has been added a wording that this exclusion extends not only to the shape itself, but also to other characteristics of which a sign may consist. These exclusions are applicable for European Union trademarks already since March last year. Not much experience. People were afraid that this will lead to many more refusals, but the actual practice has shown that this is not the case. We have a new list of absolute grounds of exclusions in Article 4 of the directive or Article 7.1 of the regulation, which relate to number of signs which had previously already been considered when looking at exclusions, namely geographical indications. The offices are obliged to examine whether a trademark applied for is in conflict with an earlier geographical indication. Now this is extended to names of so-called traditional specialties. These are protected under particular EU regulation, very special kind of rules and law. And then you have also the prohibition of registering a trademark which coincides with a plant variety denomination. Plant varieties are a particular species of intellectual property rights, biologically generated new varieties. There is, by the way, an office in the European Union which deals with community or EU plant variety rights located in Angers in France. You have a particular rule on geographical indications as relative grounds. Relative grounds, as you know, are those which are either examined ex officio, like in your country, or only in opposition proceedings. And what was previously in Article 8.4 of the regulation is now a special rule in Article 8.6 and is found in the directive in Article 5.3c. On the infringement rights, which will come before the courts on infringement matters, there are some significant changes in the exclusive rights. Among these changes is that a trademark proprietor is entitled to prohibit the use of a trade name or part of a trade name which coincides with his mark under certain conditions. Also a prohibition of using a trademark in comparative advertising against the rules on comparative advertising in European Union law. And an important provision in the regulation is that the trademark proprietor may prohibit the transit of goods through the European Union when these transiting goods bear a counterfeit trademark. Much debate in the Parliament was about this provision because it's the fight between intellectual property rights on the one side and freedom of trade. In the international system, imagine you have, even in the European situation, goods which come from Switzerland and travel through Germany, reach Holland and go on a ship and are shipped abroad. And if they have an infringing trademark, I'm sure that neither the Swiss nor the people in the country of destination would be happy if these goods were seized in Germany. However, if they're counterfeit and if the owner of the trademark in Germany or the European Union trademark has also protection in the country of destination, in these situations now the goods may be seized in the country of transit. I don't know whether you've had any cases ever in these countries on transit cases. They're important for transit places like airports and the big harbors in Europe. This is applicable already since March for community trademarks. It is not yet applicable for national trademarks because this will need implementation into national law, and the earliest that this could be invoked in your countries would be 3 years after January 2016, that is to say 2019, when the time for implementing the directive expires. But I'm sure you will bring your local legislation in line with these provisions earlier. There's also a special rule which prohibits the use on trademarks on labels or packaging, which have not yet been combined with the goods. Imagine you import empty bottles which have an infringing trademark on them and the juice or drink is not yet in there, then you can also prohibit the importation or the marketing of these packaging. This is a provision which is in the regulation already in force and will have to be introduced into the directive as well. There are changes in what we call limitations to the exclusive rights, fair use, exhaustion, use requirement, and what is now Article 14 in the regulation and the directive lists these exclusions. I will not go into the details, but there is in general a broadening of the right of third parties to make use of indications which in themselves are unobjectionable. We call this either referential use or the use of descriptive signs or non-distinctive signs. This is also somewhat reworded from a provision which already existed. An important addition to the exclusions is what is called intervening rights. An intervening right is a trademark which comes into existence through filing and subsequent registration at a time when the earlier right cannot be enforced. These are conflicting signs. They may actually be identical or very similar, but when at the time of filing the later trademark, the earlier trademark cannot be enforced, the resulting situation is coexistence. Why can an earlier trademark not be enforced at the time of filing a later trademark? For example, because it has not been used. If a trademark had not been used in accordance with the use requirement, it cannot be enforced, neither in opposition nor in cancellation. And the same thing is if it is not yet distinctive or if it does not have the necessary reputation to be enforced against a later trademark. These situations have arisen in many countries in the past. German legislation already in the 1990s adopted a rule on these so-called intervening rights, and these have now become mandatory for the European Union. They are already in force and will also be implemented in your national law in accordance with Article 8 and 18 of the directive. As regards trademark applications, one of the important issues is how you define and describe the goods and services for which you need protection. The task for trademark attorneys and occasionally lawyers and offices which examine these applications. There was a dispute in the past of whether using class headings actually covers all the goods which would potentially fit into a particular class. That has been clarified. This is no longer the situation. And what is in Article 33 of the regulation on indication of goods and services is in Article 39 of the directive and will become a part of the rules applicable by your patent office. There's a new category of trademarks in the European Union. In addition to collective marks, there will now be certification trademarks. The provisions on certification trademarks in Article 83 and the following of the regulation will come into force on the 1st of October, and from the 1st of October people will be able to file trademarks as guarantee or certification trademarks. For member states, Article 28 of the directive allows member states to introduce these guarantee or certification marks, but does not oblige them. That's one of the compromises made in the Council and in the Parliament at the time, because some countries thought, well, our certification and guarantee mark system is so different. No, we don't want to conform to a rule which is adopted in Brussels, and so the solution was that you create what is called an option for member states to make provisions for certification marks. I'm no idea on how far you are internally in your country and whether you will introduce these certification marks. But if you do, it is useful to take the rules which exist already will come into force in a few days in order to make provisions which are similar or substantially similar to those applicable at the Alicante, the European Union Intellectual Property Office. What is new for member states in substantive trademark law is there is for the first time a rule on transfer of trademarks or assignment. This was previously left to the member states on their requirements, what they do. So now you have a provision on transfer of trademarks. You have a provision on what is called rights in rem, levy of execution. All of these are now in parallel to the rules applicable to the European Union trademarks, more or less similar. And then you have what is already part of the previous legislation, a rule on trademark licenses. What is new is that member states shall have procedures in place to allow for the recordal of licenses in their registers. This is new for a number of member states. For example, Germany never had a provision requiring or even allowing recording of trademark licenses. That will have to change, and I'm sure that your system, as I assume, probably already has this, but if not, you will have to introduce it. There are procedural rules which I will not go into in detail in the directive, filing date requirements, third-party observation, division of applications and registrations. There are particular provisions on opposition, revocation, and invalidity, all of which require you to provide that defense of non-use must be available in order to defeat an opposition. This is already the rule in most countries, but not everywhere. The novelty for many countries in Europe is that they must have an administrative revocation and invalidation or cancellation procedure. There were countries like Italy and Spain, and to a certain degree also Germany and others, which never had full administrative procedure, patent or trademark office procedure for invalidating trademarks that should not have been registered. This was also much debated in the Council and in the Parliament when the legislation was adopted, and the result was that there is a longer transition period which goes until 2023 to allow member states to introduce these procedures into their national law. For those of you who are involved in litigation regarding European Union trademarks or designs, in this event only European Union trademarks. As you know, there is a particular part in the trademark regulation which deals with jurisdiction, competence of the courts, and sanctions. This used to be called Title 10, but is now Chapter 10, and there is an updated reference to the so-called Brussels I regulation. Brussels I regulation is the regulation dealing with jurisdiction and enforcement of judgments in civil and commercial matters, which has been recast in 2015. And there's a reference in article, in the initial article, to that recast regulation. There is a change in the infringement section on what we call defenses. A court before which an infringement action is pending must take the European Union trademark as valid. You cannot consider it to be invalid unless there's a counterclaim for which you are also competent to decide in a litigation, or when the defendant invokes that the earlier trademark, which he is supposed to have infringed, has not been used. This is now specifically set out in Article 127, paragraph 3 of the regulation. And then there are two, some people say cosmetic, but we still don't quite know with which consequences these changes come along. When a trademark infringement litigation is brought before a civil court, you have to determine which law is applicable to that action. Why? Because the European Union law itself only has rather rudimentary rules. And if you look into the principal article, it's Article 129, the trademark court shall apply the provisions of this regulation. This is kind of self-evident. And then there is an interesting sentence: on all trademark matters not covered by this regulation, the court shall apply the applicable national law. Applicable national law. So if you have two parties from the same country, Latvian plaintiff and a Latvian defendant, that's relatively simple, then you simply apply Latvian law to issues not covered by the regulation. But if you have parties from different countries, or you have fact situations which extend to more than one country, you run into the first problem here on determining the applicable law. In the previous version of the regulation, they had an inclusion that the applicable law, including the international private law of the court, that provision has been deleted. And some people are now contemplating whether the deletion of the reference to international private law is conflict of law, when in principle more than one legal set of rules could apply, whether that is a significant change or not. In the subsequent provision, which is now Article 130, this used to be, for those of you who have dealt with these issues before, these used to be Articles 101 and 102 of the earlier regulation. In now Article 130, it is clear when there is an infringement that the court is obliged to issue an injunction or to accept an order as requested by the claimant that the defendant shall no longer use the infringing trademark. That is a European Union rule. There's case law of the Court of Justice on this, that this obligation is mandatory and actually has no exceptions. But what happens when the claimant also requests additional relief, damages, recall of infringing products, publication of judgment, and so on? And there we have a rather cryptical provision now. The EU Trademark Court may also apply measures or orders available under the applicable law, which it deems appropriate in the circumstances of the case. Which it deems appropriate in the circumstance of the case. Previously, we had understood this to actually amount to an obligation. The court must order the available relief, damages, recall. However, with the difficulty of which law to apply when the infringement was what we call multi-state in many countries at the same time. Do you then apply for damages the law of each of the country where the goods are on the market, or do you apply a single law? By the way, there is, in this very minute, in Luxembourg at the Court of Justice, a case will be decided today that is called Nintendo, which is a design case, but which exactly has this issue, applicable law in case of multi-state infringement. This will be with you, I'm sure, for many years to come, because it's one of the more complicated issues that if you are the owner of a European Union-wide trademark or design, and you want to prohibit an infringer of selling infringing goods in many countries, the injunction is easy because the court is required to do so. But if you want to have damages or any of the other relief, yes, there is a directive on the enforcement of intellectual property rights, and that has been implemented in all member countries, but the issue of whether you apply a single law or multiple laws and how you prove it is one of the more complicated parts. So, how am I doing time-wise? I don't have a watch.
You're doing excellent.
Am I doing okay? So now, because I will now come to my second part, decisions. I had promised that I'd give you some very recent decisions of the Court of Justice and the German Federal Supreme Court. But maybe if you want to ask questions on this first part, which I gave you before I go on, or shall we do this at the end? What do you propose? So if you have any questions now on this first part, if you really want to ask questions, I'm happy to answer. By the way, I'll stay here in the afternoon, so if you want to have additional questions, you can approach me on lunch or later. No one? You don't ask questions, no?
Usually it's done during the coffee pause outside.
Okay, no questions. Part 2, divided into 2 sections. The Court of Justice, as you know, or should know if you don't know, is competent in 2 ways of dealing with cases in our field. Not only in our field, but in general, the Court of Justice is competent for interpreting European Union law. It's the final arbiter of the meaning of European Union law, and the principal way of getting there to this interpretation is what are called preliminary rulings. These are now provided for in Article 267 of the TFEU, is the abbreviation for the Treaty on the Functioning of the European Union. This used to be Article 234 of the European Community Treaty and has its predecessors in all the earlier legislation, 177 of the EC Treaty. Court of Justice shall have jurisdiction to give preliminary rulings concerning the interpretation of acts of institutions, bodies, offices, or agencies of the Union. And this means, of course, also interpretation of the trademark directive and the regulation and the acts adopted under the regulation, like the implementing rules. Who must refer a case to the Court of Justice, a court of last instance, before which a question is pending which requires an interpretation. Where any such question is raised in a case pending before a court or tribunal of a member state against whose decisions there is no judicial remedy, that court or tribunal shall bring the matter before the court. This is mandatory on the highest instance in a particular case. Other courts, lower courts, may refer cases for preliminary rulings. They are not required to, but they may. And the practice in member states is quite different. English courts, with their sovereign judges, even in the High Court at first instance, have the habit of often referring cases to the Court of Justice even before they are decided on appeal in second instance. Most of these references in our field of law come from 3 or 4 countries, Germany, England, the Netherlands, or the Benelux countries. Very, very few cases so far have been referred from courts in your jurisdictions, but of course that may change over time. So this is the one way to get to the Court of Justice, so-called preliminary rulings. Mandatory for the court of last instance. So if you are a judge, as I know some are here, a court of last instance, and you have an issue before you which requires interpretation, you must refer with the proper questions to the Court of Justice. The second way of getting trademark cases to the Court of Justice is what are called appeals. These are appeals against decisions of the European Union Intellectual Property Office. That office internally has an appeal procedure where cases come to the boards of appeal. I know you also have an IP tribunal in your country. In Alicante, the situation is such that, for example, an examiner refuses a trademark, the applicant appeals to the Board of Appeal. If the Board of Appeal rejects or confirms the examiner, then the proprietor, the applicant, can bring a case in the Court of Justice. The Court of Justice is, as you know, divided by, there are 2 instances. There's the so-called General Court, and that is where these cases begin. And then there's the second instance on points of law. That's the Court of Justice, properly speaking. Is this done very often? The boards of appeal in Alicante decide about 2,500 cases a year. 2,500 cases a year. 2/3 opposition, 1/3 are so-called ex parte cases on registration. Of these 2,500 cases, about 200 to 250 each year reach the General Court. So the General Court decides about 3 or 4 cases a week. And one of the tasks, or difficult tasks for the experts, is follow this meandering case law throughout the year. And from these 200 or 220 decisions, some cases are settled and don't need to be decided. About 10 to 15% go to the Court of Justice itself. So the Court of Justice has about 20 to 25 cases a year, which are appeals against decisions taken by EU IPO. So compared to the jurisdictions in your countries where the cases involving trademarks and designs are not every day and don't occupy you entirely into your entire career, there are people involved in trademarks at the Court of Justice for whom this is basically daily activity. Now, the judges at the Court of Justice, as you know, there's 1 judge in the Court of Justice for each member country, so there are 28, still, soon to be 27. And at the General Court, the court below, there are now 2 judges per country. So they have 58 judges. And that's quite a significant number for dealing with about 1,000 cases a year. But you can imagine what kind of tasks they have. Each judge is reporting judge in about 25 cases a year, so they have plenty of time compared to your local judges, or even in my country, single judges have several hundred cases a year to deal with and not 20. Now, these judges in Luxembourg have also a particular pleasure. I don't know whether you call it pleasure. I call it a pleasure, because they have a cabinet, and the cabinet has 3 lawyers for each judge. So the judges have plenty of time to deliberate with their clerks or with their referendaires, as they're called, all of whom are great experts in intellectual property law. So they have a much easier time, I'm sure, than most of you have. If you come to the office and you have to do your cases alone and write the judgments and have little time to negotiate with your colleagues. Anyway, so they live in a relative heaven in Luxembourg, the judges, and but of course their decisions govern a field of law for years to come. Now, I'm going to show you a small number of recent cases decided by the Court of Justice in our field of trademark law. We begin with registrability, and we have this interesting sign, which is a packaging for chocolate with a blue and white, you see the shape, blue and white? It's like, they say, it's like a mountain shape with snowy mountains and blue sky. And the issue that had to be decided are two. First of all, a two-dimensional trademark, which this is, it's a figurative trademark. Is this judged under the same standards as a three-dimensional shape? This has been previously answered by the Court of Justice at several occasions. They say, yes, a two-dimensional representation of a three-dimensional shape, like in this case the packaging, is judged under the same standards as a three-dimensional trademark. And the standard for these cases is that a shape is registrable only if it departs significantly from the shape that is customary in the particular part of the trade. So here you have a square packaging for chocolate that doesn't depart significantly from existing shapes, so therefore, aside from the issue of the graphic representation, the trademark would not be registrable. Now comes the question, what is the relevance of the figurative element on the trademark? And there the Court of Justice comes to the conclusion in this case that this particular graphic addition is not sufficient to confer distinctive character because, anyway, if I ask myself the question, because I always have a little doubt, because I don't often understand the reasoning. I understand the result. The figurative element is not significant enough to confer distinctive character. But when you ask, well, why in this case not sufficient, in other cases sufficient? Anyway, this is to show you that the court takes the view that the addition of such a figurative element to an otherwise unregistrable shape mark is not sufficient to confer distinctiveness. Now, you must understand that the Court of Justice is dealing with this as points of law. So it examines the question whether the general court, where the case comes from, committed an error of law when concluding that this is not enough to confer distinctiveness. And there the Court of Justice usually says, well, these are questions of fact. Is it distinctive enough or not? And we are not reviewing questions of fact, and therefore the decision of the general court stays. Next case. Have you seen this before, perhaps, or looked at this? These are, depends what it is. What did the applicant say? The applicant says this is a graphic representation which has a border and an arrangement of black dots. Nothing. So the office said, no, this is the handle of a knife. This is a Japanese company which makes famous knives for kitchen, high quality. The company is called Yoshida. And they had even supplied evidence that this is how the knife looks. So the office said, this is not a graphic representation of an arbitrary shape. No, it's the picture of a knife handle. And as a picture of the knife handle with these dots actually have a technical function because they prevent the slipping when you're cutting meat and your hands get greasy or bloody. You can hold on to the handle and it's safe. So That case has a very, very long history. It has been up and down twice at the Court of Justice, and was just decided now in May this year. And the court confirmed a refusal of this registration because it's a technically necessary element is not a violation of law. The General Court has the right to decide in this way. And the important element in this case for us as practitioners is that the Court of Justice said, as the General Court said, in order to identify what the mark actually is, we are not limited by looking at this picture, because you can interpret this picture as in many ways. No, you are entitled to look at what is actually on the market. Now, these cases are not very frequent that a trademark necessarily corresponds to what is already on the market, but if it is, the examining office is entitled to look at this. We have a very recent case decided by the Court of Justice. If you look at it, 14 September, that's just 2 weeks ago, or less than 2 weeks, tomorrow, 2 weeks. There is the place in Portugal, which is called Porto, and in Porto you make port wine. You know port wine, it's a fortified wine made from grapes which grow in the Douro Valley, which is a river coming from Spain and finally flowing into the Atlantic in Porto. And there was a trademark called Port Charlotte for whiskey. And the people in Porto, there is an Instituto dos Vinhos do Douro e do Porto. They are charged with protecting the intellectual property in the name Porto. They thought that whiskey mark having the name Port in it is an infringement of our rights in the name Porto for our fortified wine. And that case went to the Court of Justice, most recently decided. And the issue in that case is whether, in addition to the rules on geographical indications, which are found in European Union legislation, in this case relating to wines, they have a whole set of rules on how to protect GIs for products like Porto, whether in addition to these rules, you are also allowed to apply national law. The Porto Institute said, we in Portugal have particularly strong rules in protecting our geographical indications, and these go beyond the minimum protection available under European Union GI protection, and therefore we can prohibit this Port Charlotte registration even if under the EU wine legislation we cannot. This argument was accepted by the General Court. The case went to the Court of Justice on appeal brought by the European Union Intellectual Property Office. They didn't like this decision. And the Court of Justice said, no, the EU legislation on GIs is preemptive. It's the only rule you apply. You cannot go back on more extensive protection under national law. So the case was decided in favor of the whiskey makers because the Court of Justice also said in deciding that under the EU wine legislation there was no protection, the General Court had not committed any error of law. I have a single case or two cases on conflict. Conflict is opposition or invalidation. You may be familiar with the German Meissen porcelain. It's famous for high quality, very expensive. And there was a second company that filed for trademark Meissen with a little figure of a swan or whatever this animal is, I assume it's a swan. And the question was, can Meissen prohibit registration? This case is in a way particular because on the issue of burden of proof, on use and so on, something went wrong. So the only conflict that was to be decided was whether the word Haus Meissen, rather than Meissen itself, could prohibit the registration of the later word Meissen. And there the Court of Justice said, no, the General Court could decide that there's no conflict. Why? Because Meissen itself is only, if at all, very weakly distinctive, because it's the place of production. And as a weakly distinctive part of the house Meissen and a weakly distinctive part of the Meissen Swan trademark, no conflict. This points to a difficulty in the case law when you have composite trademarks, each of which is composed of a weak or non-distinctive element. And the only element which coincide is this weakly distinctive or non-distinctive element, and practice on these issues is widely different even in Alicante. This is an example which highlights these difficulties. A little earlier, this case was decided by the Court of Justice, and I wonder what you would think if you see a conflict between X and X-King for tires. The X is a famous trademark by Michelin, and the other one is X-King Germany. The issue there is similar. Individual trademarks, trademarks consisting of a single letter may as such be distinctive. Usually they are considered not very strong. And the question is, when someone incorporates such a single letter in a second trademark, is there a conflict? And I don't know how you would decide this, but the Court of Justice said, yes, there's a conflict. There's no rule that a weak element like X, when incorporated into a second mark, doesn't lead to likelihood of confusion. It's a case worth reading because it shows you how the Court of Justice deals with appeals from the General Court. The General Court does a much more exhaustive analysis, whereas the Court of Justice usually limits itself to points of law. Tommy Hilfinger, 7 July, that's already last year, but I thought it's an interesting case. Someone is operating a marketplace, in this case in Prague, in the Czech Republic, where people are selling counterfeit goods. So Tommy Hilfinger and another dozens of other companies were suing Delta Center, so they were not suing the sellers of the infringing goods, but the operator of the marketplace. Imagine you have a stall, and there are all these stands, and so they sue the owner of the marketplace. You are responsible for allowing this infringement to occur in your premises. And here the Court of Justice was called upon to decide on the so-called enforcement directive, which has a provision on what we call liability of intermediaries. These are persons who are not themselves infringing, but they are allowing others to infringe in the broadest sense. This issue has arisen previously in the internet context. That's the L'Oreal case, where the eBay, in a certain situation, may be responsible for infringing goods sold on their website or on their marketplace. And the Court of Justice extended that rule and said, yes, also the operator of the market in Prague may be liable for infringing or may be enjoined or has to do something to prevent these infringements from happening. I have another complicated infringement case where an earlier mark, combit, was sought to be enforced against a later mark, commit. And the court in Germany said, well, there may be infringement in Germany because people don't really understand what commit means, but there's no infringement in England and other English-speaking countries because commit has such a particular meaning, and this leads away from infringement. What shall I do? Here the Court of Justice decided, yes, there may be situations where for linguistic reasons no infringement in one part of the European Union, infringement in another part. This is a sign used by a company to indicate that a product is made of cotton, genuine cotton. The mark is owned by a German association, and they grant licenses. And the infringer said, who was using a similar sign, said, this mark must be declared invalid because the cotton mark is actually used as a guarantee certification mark. It's not actually used as an individual trademark, therefore no use requirement. It is also misleading because the owner does not exercise control with the licensees whether they actually fulfill the requirements of the license agreement. Here the Court of Justice says, yes, the use as a mark, as a certification or guarantee mark may not amount to genuine use. However, it is possible that a mark is used both as a guarantee mark and as an indication of commercial origin, and the national court must do this. And then complicated statements in which I will not go into the details on the relationship between misleading trademarks and collective trademarks. I have a few more cases. Tell me, how am I doing by time? Do I have
So now we are roughly 20, 25 minutes left.
that much time I still have?
Yep.
You're not yet tired listening to me? It's a little complicated. So another recent case, just a few weeks ago, Ornua Cooperative is an organization in Ireland of dairy companies who produce, among others, butter. And I'm sure that in your stores you find butter called Kerrygold. Irish butter, no. Golden Pack, quite well known in many parts of the European Union. And there's a defendant whose name is Kerry Group, who are also located in Ireland, by the way, in the county Kerry. This is a geographic name. Who are selling a similar product, including in Spain, through a distributor whose name is Tyndale and Stanton. And the Irish Ornua, who used to be Irish Dairy Board, brought an infringement action in Spain in the Spanish European Union Trademark Court in Alicante, and said, we want to prohibit the use of Kerry made on the basis of our earlier trademark Kerrygold. Now, in analyzing the conflict, you would say these marks are quite similar because they have the same element in the beginning. Gold is weak and made, we don't know. Anyway, they said these marks are sufficiently similar. Also, my Kerrygold trademark is famous. It's well known, at least in parts of the European Union. And the defendant said, the only element which these marks have in common is the element Kerry. And Kerry is a geographical name because it's the county Kerry in Ireland. And we are located there. We're actually making products in the county Kerry, and therefore this is a geographical indication, and this geographical indication should not be monopolized by someone like the Ornua, the dairy people. They also said, for many years, actually decades, the mark Kerrygold and Kerrymade have been used in Ireland and in the United Kingdom without any conflict. So the argument is what is called peaceful coexistence. No conflict. Whatever the reasons for this absence of conflict are, we would assume that the absence is based on the fact that Irish and English people know very well that Kerry is a county in Ireland, and therefore are not confusing Kerrygold with Kerrymade. Also long use, no conflict. So the defendant in the Spanish case said, the fact that these marks are peaceful coexistence in Ireland and the United Kingdom is an element which the Spanish court should take into account in deciding whether there is confusion in Spain. So the court of first instance said, yes, this is a relevant element. In addition, no conflict because geographic name, case dismissed. The case comes for the second instance court, Alicante again, and the judges in Alicante said, well, let's ask the Court of Justice And the specific question they asked was, can we, what is called extrapolate, can we use the fact that there is peaceful coexistence in Ireland and England and apply it directly or not? I can apply this fact to the situation in Spain with the consequence that there would be no likelihood of confusion in Spain as well. Rather complicated question, but these situations are not entirely unusual, that the situation on the market in the European Union, while you have a community trademark, European Union trademark, as far as the use and distribution and perception of the public obviously is not necessarily the same because of languages and distribution habits and market situation. And the Court of Justice in this decision just come out said that the fact that there's peaceful coexistence in one part of the market does not allow the conclusion that in another part of the European Union, where peaceful coexistence is absent, there is no likelihood of confusion. So no automatic transfer of the findings for one part of the community to another part of the community. This is not surprising because it's kind of obvious that you don't make automatic assumptions in the situation that you're facing at. Now, the more important part is what happens in the analysis. The argument that the defendant was made, no, there's no automatic transfer of the situation in Ireland and UK to Spain, but the court must take this into account among the many elements that they have to judge when deciding on infringement. And in a way, the Court of Justice recognized this possibility, and they say they may be taken into account by that court to assess whether there is infringement, provided that the market conditions and the socio-cultural circumstances are not significantly different. So in addition to the linguistic differences which we had under the commit trademark, where differences in languages led to the situation that in England no infringement, but in Germany yes, here we have market conditions and socio-cultural circumstances. The case is now back at the Court of Second Instance in Alicante, and we will see how that comes out. I have to disclose that we are representing the defendant in that case, not in the Spanish case, but I argued the case in the Court of Justice for the defendant earlier this year. But it's an interesting example of where conditions in the European Union, even though you always assume there's a European consumer and he has a particular perception, actually are quite different. What happens if you sue a company in Germany for trademark infringement on the basis that the infringer has an establishment in Germany? Not that the infringer is itself in Germany, he is not, he is a foreigner, but he has an establishment in Germany. And there's a rule in the so-called Brussels I regulation, I'm sure you have had to deal with this. Brussels I regulation, concretely, it's what is now Article 8, number 1, used to be Article 6, number 1 of the predecessor. And there's a particular rule in the community, in the European Union trademark regulation, in what used to be Article 97, is now a different rule, that if the defendant is not located in the European Union, but he has an establishment in the European Union, then you can sue him where the establishment is. You don't have to bring the case against the foreign defendant outside of the European Union where the establishment is. And this particular instance had the difficulty that the so-called establishment in Germany was actually a second-level subsidiary. In this particular instance, it is Nike. They had a European subsidiary in one place and a subsidiary of that subsidiary in Germany. So in a way, it's a granddaughter of the foreign defendant. And the Court of Justice said, yes, even the granddaughter may be sufficient to establish jurisdiction over the foreign defendant, provided that this establishment is seen as part of the general operation of the defendant. The fact that the granddaughter is a separately incorporated entity, a GmbH or whatever company form that is not a sufficient defense. Then I have an interesting case which came from your neighboring country, Irina Nikolaeva. What happened there? The case was brought for infringement, and the defendant had stopped its infringement, and the question was, even if the defendant has stopped the infringement, do I still get an injunction? He doesn't want to continue, he doesn't continue. So the answer that the General Court that the Court of Justice gave, it is possible to abstain from ordering injunctive relief, even though as a general principle you must, depending on the particular circumstances, pursuant to certain principles of national procedural law, from issuing an order which prohibits a third party from proceeding with acts of infringement on the grounds that the proprietor of the trademark concerned has not applied for such an order. So the plaintiff didn't even want an injunctive relief because the defendant had already stopped. The second part of this Nikolaeva judgment is interesting because it deals with damages. Damages accrued in the period between publication of the European Union trademark and its registration. And here we have, from my observation anyway, a general problem in these cases that reach the European Court of Justice, where their familiarity with the law of damages is not yet established. They have to do this on a case-by-case basis. And here, for example, they decide that you can actually get recovery of all the profits made by the defendant in this period, which we find strange because the basic rule says you can get reasonable compensation for this period and not recovery of profits. But the Court of Justice said even for this period where the plaintiff does not yet have full 100% trademark rights, you can get recovery of profits. I will finish with a few judgments coming from the German Federal Supreme Court, which also has jurisdiction over appeals from the German Patent and Trademark Office on appeal points of law and on appeals on points of law from courts of civil jurisdiction, where we have three instances in Germany: Landgericht, Oberlandesgericht, and finally the Bundesgerichtshof. The court decides in the neighborhood of 10 to 15 trademark cases a year. So it's also very specialized because it deals with unfair competition and copyright. Our Federal Supreme Court is divided into civil chambers and criminal chambers. And this particular first chamber, Erste Senat, deals with intellectual property matters except patents. These are dealt with in a different Senate, the 10th Senate. So on registrability, I have an interesting case which has confronted offices everywhere. The word we, or yes, or whatever it is in your language. The question is that a good trademark? For what? So in this case, for clothing. And there have been cases like this dealing with trademarks like hello or ja in German and hola. All of these are exclamations which, depending on the circumstances, are used by many people and are not trademarks. So in this case, there's a whole line of case law of the German Court of Justice in these issues. The court said the evidence which the Federal Patent Court, from which the case had come, had relied on to refuse registration of "we" was not sufficient because the use of "we" had always been in conjunction with other terms. So the case turns on evidence. The applicant says the trademark is distinctive, the office says it's not distinctive, and here's evidence of non-distinctive use, and then the case goes to the court. And the question is, who has the burden of proof? Now, under the German approach, the burden of proof would lie with the office or with the Federal Patent Court. And in this case, the decision was that the evidence which had been provided by the Federal Patent Court, which is a de novo procedure, is not sufficient to prove that "we" as such is merely laudatory. The laudatory sales appeal, this is translation from German, of a designation precludes its suitability to function as an indication of commercial origin, as a trademark, only if the public perceives the designation exclusively as an advertising message. Exclusively as an advertising message. And that turns on evidence. And if the evidence is not there, the mark will be registered. A similarly close case is Stadtwerke Bremen. Bremen, as you know, is a city on the German North Sea. Stadtwerke means city works. What do? They provide electricity or water or run the tramways. It's a public enterprise, Stadtwerke Bremen. So question, is that misleading when the owner of this trademark is not the city of Bremen, but someone else? So the court said, general principle, in this instance, the city of Bremen was a minority stakeholder in the Stadtwerke Bremen. They said the trademark, the trademark is misleading only if there is no use possible which is not misleading. And so the analysis was the Stadtwerke Bremen may be used in a manner which does not mislead about the ownership of the city of Bremen. The more interesting part is that is Stadtwerke Bremen descriptive of the activities exercised by the Stadtwerke Bremen? And most people would say, of course it's descriptive. The Stadtwerke Bremen provides us with water, electricity, and transportation, and they're generally caretakers of our interests. So the federal court disagreed. They said, Stadtwerke Bremen is not lacking in distinctiveness, not descriptive, because it describes a specific enterprise, not any particular one. And the descriptiveness definition is it may be used by any other company to indicate its goods, services, and so on. It cannot. And that's an interesting indication on how to analyze the descriptiveness refusal. Descriptiveness, if you read the text, says, the offices shall not or may not be registered signs or indications which consist exclusively of indications which may be used in the course of trade to indicate the origin, the place of production, the time of production, the geographical origin, or any other characteristic. Now, Stadtwerke Bremen may only be used by Stadtwerke Bremen to describe these activities. That's the analysis of the court. Most people will have their doubts about this judgment, but it's an interesting facet of, generally speaking, a rather, let's say, pro-trademark applicant attitude of our Supreme Court. Have you seen this one before? This is a red abstract color mark used in Germany by Sparkassen. Sparkassen are savings institutes, usually publicly owned, and they are fighting for many years in Germany against a Spanish company which is called Banco Santander. I don't know whether Banco Santander has already appeared in your jurisdictions, but they also use a red, which is quite similar. So there are infringement actions going on in many courts, and the Banco Santander asked for cancellation of this registered trademark claiming that it is not actually properly registered, because the claim of acquired distinctiveness, everyone agrees you get a color trademark like this only with proof of acquired distinctiveness, has not been sufficiently substantiated. The case went to the German Patent Office that refused the cancellation. It went to the German Patent Court, which referred the case to the Court of Justice, wishing to know what the criteria are for proving acquired distinctiveness by public survey evidence. That case had come back. The Federal Patent Court, after the referral back to the Court of Justice, from the Court of Justice, actually invalidated the trademark because they said the requirements are not met, and it then reached the Federal Court of Justice, which decided already a year ago that this trademark should not be cancelled because the evidence showed that at least 50% of the relevant public recognize this color as a trademark. A survey showing a market recognition of above 50% may suffice to show acquired distinctiveness. Long debates in Europe about so-called survey evidence in showing acquired distinctiveness, or for that matter, anything else, the likelihood of confusion or reputation. German practice has always recognized this evidence. We have institutes which have great experience in making public opinion surveys in this and in many other fields. And the 50% line has been set by the German Federal Supreme Court in previous judgments. If you look at the case law of the Court of Justice, they are very skeptical to recognize opinion survey, probably because they are not sufficiently familiar with the manner in which this evidence is collected. A trademark dorso is used in class 5 with other terms, dorso vision, dorso comp vision. Question, is this genuine use of the trademark dorso? Recurring question, you use a trademark registered not alone, but together with other elements. And here the other elements are those given in this middle line. And here that is an infringement case where the Court of Justice says use of a mark in conjunction with other elements is not use of the mark as registered, but use of a variation. And then you have to analyze the use of a variation under the rule does not alter the distinctive character of the mark as registered. So in this particular instance, no genuine use. This is a message, of course, for trademark owners. If you have a trademark like dorso, be careful when you use it that you don't put it together with other elements which kind of camouflage the trademark character of your mark. An infringement case, Medicon, Medico, Apotheke, quite special. We have parallel importation cases in Germany. You have parallel importation cases here. This is a product imported from Italy into Germany, parallel. Question is whether the inscription in Italian on the product is sufficient to allow its marketing in Germany. The answer is that perhaps, but the case has to be rejudged by the lower court. So now this is my final case. You don't have it. You don't have it. I just added it 10 minutes ago. You know what this is, of course, right? Now, I also know what it is, of course, the bear. It's not the prime minister of your neighboring country who has this as part of his name. Huh? So a question that had to be decided not too long ago, 2 months ago, is this a good trademark for classes 29, 30, 31? You know 29, 30, 31 is foodstuffs. So first question is, if you are a Russian speaker and you see vedved or whatever it's called, and you wish to understand whether that is descriptive of foodstuffs like meat, Would you think this is descriptive of meat because it may also be bear meat that you're having there, or tartar, or living? It's actually also for living animals. Well, for living animals, I think bear is a good description of a living animal. Although, but that's the first question. The second question is, how does a Russian language word even arise in the European Union, in Alicante? Which country has Russian as language? So, you of course know, no country has Russian as official language. There are only 24 official languages, and Russian is not among them. But of course, you're very much aware that in this country, more so than in Estonia, but also in Lithuania, there is a significant minority who speak Russian. So the legal issue is the office in Alicante obliged to take into account non-official languages used by a not insignificant proportion of the relevant public in some member states? And what do you think the answer is? The answer is yes. Now, I cannot give you this in English because the case has been published only in German and French, but some of you, of course, may know sufficient German to read this. So, the examination under the European Union trademark regulation shall not be limited to official languages. That's a novel thing. But there are previous cases which dealt with the language of Catalonia. Catalonia, you know, is just about to vote on separation from Spain. Of course, they're not going to separate. Don't be afraid, they're not going to separate. No one is going to allow it, but they're going to vote anyway. So the Catalan language is a variant of medieval Spanish, Latin, whatever, maybe a little bit similar to what they speak in Malta, if they don't speak English. Anyway, that has already been taken into account once, and there are a few other cases. But and I finish with this interesting case because there is a willingness of the Court of Justice, no, in this case the General Court, not yet. I don't know whether this is going to be appealed. That a trademark which looks like this cannot be registered as a community trademark because there are some parts, in particular in the Baltic countries, who speak and understand Russian. That's it. That's the end of my presentation. I hope I'm still within your time limit. I know you're all waiting for lunch, and we began a little late, as I know. But I'm not the guilty one for coming late. It's the bus, traffic.
No, you managed perfectly in time.
Thank you.
And I would like to thank you for this very interesting and exhaustive presentation. And of course, as well, we are preparing for the implementation of the directive, and I think for us as well, the first question will be to decide whether to draft a new law or to amend the existing one, and as well whether we need to do these certification marks. Un tagad, kolēģi, iespēja uzdot jautājumu Mīlendāla kungam, tā ka droši pirmie.
Thank you for a very interesting presentation. I will ask in English just to have a better understanding of my questions. And they both are regarding surveys as relevant evidence, which you mentioned at the red color case. And you said that post-registration surveys were allowed as relevant evidence. Regarding what time, whether there is enough of market recognition at the moment of when the case was seen, or actually in the registration moment. That's one question. And the second one, okay, 50% or more than 50%, that's safe enough. But regarding the same debate which is going on in Europe and which you also mentioned, what if there would be, let's say, 45% or 20%? Thank you.
Okay, first point, at what time must, in this particular instance, proof of acquired, to which point in time must proof of acquired distinctiveness relate? The Court of Justice has said in a case that is called Flugbörse, that for registration purposes, the filing date is required. That's the general proposition. The directive doesn't prohibit, and the regulation actually provides that if you can provide evidence of acquired distinctiveness at the time the invalidity action is decided, your trademark will not be cancelled. This is what we call post-registration acquired distinctiveness. So if the office has made a mistake in registering a trademark which it should have required distinctiveness, or the evidence is not sufficient, if the owner of the trademark can show acquired distinctiveness at the time the invalidity action is decided, the trademark cannot be cancelled. There may be an issue of intervening rights, but so you have two relevant points. German law has another specialty which says the following. If you are unable to show acquired distinctiveness at the filing date, but in the ongoing process of registration, which may go up and down and may last many years, you are now able to show it, you will get your trademark anyway, but with a different date, namely with a date when you have shown registrability. It is doubtful whether this rule will survive the directive, because the directive is not explicit enough of allowing this. But so in Germany, actually, you have 3 dates: the filing date, if not in the registration, or the invalidity date. I'm sorry. There is another part of your question is, what is with post-survey evidence? You have a filing and you think you have a distinctive trademark. The office says it's not distinctive. So you make a survey on acquired distinctiveness, which comes 2 or 3 years later after the filing date. Can you take this evidence, which is relating to a later point in time, to prove distinctiveness acquired at an earlier point in time? And there the practice in Germany is, and I think Alicante would do the same thing, if you can show that the market conditions at the filing date were the same as they were when the evidence was acquired, you can date back and you can argue. I had a market share of 35% for my financial services prior to date X, and now 3 years later I show acquired distinctiveness, but the market penetration hasn't changed at all. Then you would say, yes, it applies also to the earlier date. And that is a frequent situation, that you are forced to come forward with additional evidence in the course of litigation or in the course of a pending case. And then if you were strict and said you can only present evidence which was collected prior to the filing date or prior to that and that date, you would actually do a disservice to what you can show with survey evidence or any other evidence. By the way, this is applying evidence of today to a fact which is earlier is not limited to the issue of survey. And the third part of your question is, what happens if it's 20, 45, 50%? Now, in Germany, we would tell people, don't present this to the court. Keep it for yourself. And argue, because there are many other ways of showing acquired distinctiveness. You do not necessarily have to present survey evidence. You can do marketing efforts, sales efforts, advertising, length of use, market share, Nielsen, whatever, showing the presence of the trademark before the relevant public. Why is that important? Because the Court of Justice has so far refused to accept percentages. The Court of Justice has said a trademark has acquired distinctiveness if it is recognized by a significant proportion of the relevant public. Significant proportion of the relevant public. So relevant public, significant proportion. And unless you have some idea what significant proportion would mean, it's very difficult to say where that will lead you. In Germany, if you have survey evidence and it shows above 50%, you're safe. In Germany, if you have survey evidence which is lower than 50%, I wouldn't present it, because the courts are so strict on this 50%. Now, is this just? I think it's just in a way because you're not limited to survey evidence in showing the significant proportion of the public. I don't know what your understanding would be, a significant proportion of the public. I would always say, well, 25% is certainly significant. Every fourth consumer knows that this is a trademark. Can you prohibit the others from using? No, because you have this fair use of descriptive terms. They can continue using in a non-unfair manner. But, and then if you do that and look at the whole of the European Union, it is quite well recognized today that it's basically impossible to show acquired distinctiveness in the European Union. Why? Because you have to show it for the whole Union, and some people say that means for every member state, including Malta, Cyprus, and I don't know whether the Canary Islands as well. There's a case currently pending in the Court of Justice, in the Court of Justice, fight between Nestle KitKat Shape and Mondelez or Cadbury, where they challenged the validity of an EU registration for the four-finger shape. And 3 parties have appealed against that decision of the General Court. The European Union Intellectual Property Office, because they think the requirement to show acquired distinctiveness in all member states is excessive. Nestle, because they don't like the outcome on particular elements, and Mondelez, because they don't like it on other parts. So the Court of Justice will have to decide that case probably sometime next year. It's one of the most significant cases on this issue, acquired distinctiveness, scope of protection, means of evidence, that will come up. A rather long answer to a very interesting question. I'm sorry that I was a little longer than... Thank you.
Paldies, varbūt vēl kādi jautājumi? Izskatās, ka visi jau gaida pusdienas. Nu tad teiksim lielu paldies vēlreiz Mīlendāla kungam un
I do thank you very much for your kind attention, and as I said, I'm available if you want to ask questions over lunch or afterwards. I wish you a good conference. I'm going to listen in the back later, trying to follow your nice language. Thank you.